Good, yeah.
Okay. So the architecture is all grand and you're saying that it's intentional, right? It's to create a sense of prestige and power. What else? What did you feel when you were in the building?
Kind of like this grandeur. type of
Grandeur of the
feeling.
building.
Yeah.
Feels like is it a very funny place? No, because they want you to feel the opposite. They want you to feel very serious.
Yeah.
Like what's going on there is very serious. These are important. Sometimes life and death matters going on in this building. They want it to be, they want to be taken seriously. And broadcast people, hold up your hands. And either video or still photography. So, do you know that cameras aren't allowed in the Supreme Court?
Yes.
Why do you think that is?
Because a lot of these cases are very important that are in there, and they don't want anything that goes on in there to somehow like end up on YouTube or something, and the whole world to see. So they want it to be what goes on in the Supreme Court stays in the Supreme Court.
What goes on in the Supreme Court stays in the Supreme Court.
Is it kind of like a tradition thing too?
Custom and tradition is very important in the law, and so it's always been that way. And they would hesitate to make some change that would be so different, right? If it could be just a small incremental change, they would be more inclined. For example, on really big popular cases, but just one second, when there's like a case that they're hearing that has a lot of interest, a lot of public interest, they'll release an audio recording of the oral arguments. Or if they've spoken from the bench when they release the decision, they'll release an audio recording. So the court is more comfortable with a small change like that to provide a little bit of transparency so we can hear what's going on. But I just don't think in my lifetime they would agree to the change to have video cameras in the court. I don't think so.
I was just gonna say the cameras, both still and the broadcast cameras are a distraction. They need the justices to be fully focused on what's happening on the case and not some photographer moving around.
Right.
Taking pictures.
Another good rationale. From the videotape, how long do you, if you're arguing a case before the Supreme Court, how long do you have?
30 minutes.
30 minutes. That's it. And every second is precious. And you don't want any distractions. You don't want anything, pulling the attention of the justices away from your tiny little moment in time to argue the case, right? So part of it is they're trying to protect that feeling of seriousness. They're trying to limit distractions. They're trying to protect the gravitas of what's going on. They don't want it to be just, videos on YouTube, right? Like a reality TV show, Survivor Supreme Court edition. And they don't want it to be like that. They want to protect, the gravitas of what they're doing. So I don't think they'll ever allow that. What else jumped out at you or made you curious in the tape or caught your attention that you thought was either interesting or neat? Or I thought most people are shocked when they find out that a case only takes 1 hour, 30 minutes per side, that's it. Right? Because you would think these would be big, complicated cases and they take longer. That's really surprising for most people.
I thought the concept of how much they rely on the people's good faith was interesting, because it's something that gets often overlooked, because they're often assumed to be kind of their own separate entity that's just kind of separated, and something comes in and comes out. It's really not just a process at all.
Right. So how do you square these two seemingly contradictory statements by Souter? At the beginning of the tape, he was talking about after the nomination process is over and somebody becomes part of the court, the public doesn't have any more input. But then at the end, he says, same person, says, the power of the court is the power of trust earned, the trust of the American people. So how do you square those two different ideas, what do you think? Why does the court's power rely on the trust of the people? Have you ever run a stop sign or a stoplight when no one was around? come on, everyone has done it, I've done it. It's like, it's 5 or 6 in the morning and there's nobody around for miles, and I've done that as tempted. Because the law is nothing but, it's just words on paper, right? It doesn't mean anything unless we believe in the laws and we agree to it. We give our consent. It's the whole ball of wax about the entire political system that we created in America, including the judicial part of it, is that the government gets its authority only from the consent of the governed. That's the central animating principle of the American project. And no other government in the world had ever been organized in that way. The government gets its authority only through the consent of the governed. And the law that the Supreme Court announces when they announce a decision, it only gets its power, it only gets its strength if we agree to go along with it. Otherwise, it would be like running the stoplight at 5 o'clock in the morning. We might decide, I'll just ignore it. I'll just ignore the law. Can you think of any times when, so the court actually, even though this is really a sort of legal fiction, the court claims that it's completely independent from public opinion, public sentiment. Do you think that's true?
No.
No. Because what would happen if they weren't? What would happen if they issue a decision that just seems so out of step with where America is?
It would be very unpopular.
Very unpopular.
We would respond.
And people would respond to that, maybe through anger, it might spark protests. There's an impeachment process for judges too. I mean, you have to remember, they're not completely separate from the people in so much as they're appointed for life. That's true. Once a Supreme Court justice is appointed, they're appointed for life. They serve at the pleasure of the president. Why do you think we do that? Why do you think judges are appointed and then they're there for life? Like, the president can't fire a Supreme Court justice.
So that you get judges for an extended period of time so they get more experience.
That's an excellent reason, because they do get better. They're like wine. They get better because they get more knowledgeable, more nuanced in their thinking.
And also, unlike Kevin, so that the president can just choose who they want and who they don't want. So they can't kick someone else out and put someone else in. There has to be a seat open due to death or resignation.
Right. Because we don't want the president, this is an example of what, we don't want the president to have that power to simply kick someone off the court. So that's an example of checks and balances. We're trying to keep the president in check and keep them from having too much power. It's that construction.
It's
Didn't it say in the video that it takes a couple of years to adjust anyways? So if you're switching every 5 or 10 years and it takes them 3 years to adjust, it's like not getting
That level of expertise that we want, right? And we want to also,
It's also important because the judge's decisions need to not be influenced by whether or not they could be fired for making that decision.
right, we don't want them to feel like there's a sort of Damocles hanging over their head every time they make a decision. We want them to make a decision based on what they see as, how they understand the law. We don't want them to be thinking with political motives. Like, oh, it's such and such president in the White House, I better try to please him by deciding in this way because he could fire me. And so we want to remove them from low politics. We talk in law about low politics and high politics. Low politics, and this doesn't mean like in the gutter or something, just means like your everyday politics, your Congress people getting on TV and grandstanding and running for office and just everything that happens on a day-to-day basis. Then high politics being thinking in a much bigger historical arc about how politics and the nature of the country changes over long periods of time, and the Supreme Court is part of that because it has to keep calibrating and recalibrating the law over time to stay in step with changes that are happening in American society. right? And so they say that they're not political, but of course they are. All human beings are political by nature. And you know, you'd have to be a robot. We'd have to have robots on the Supreme Court for it not to be political at all. But our hope is that they will be participating in a sort of national dialogue that's happening more up here in a longer arc. So you see, for example, and so one thing that shows you, another thing that shows you how, well, you tell me if you can think of any recent cases that show the court issuing a decision that shows changes in American society. Can you think of anything? Anybody a court watcher? Can you
I
think?
mean, I found Prop 8 to be relatively interesting.
The Prop 8 case, which was also combined with, what was the other issue?
It's Marriage Act.
DOMA. So that's a perfect example. This happened within the last 6 months. The court comes out with a decision, and it has to deal with Proposition 8 in California, outlawing gay marriage, and the Defense of Marriage Act. So that's a state law, and the Defense of Marriage Act, which was a federal law, and they brought those two together and decided on those two things. And so what's interesting is it's not that long ago where, well, I'll just tell you, we could take it case by case. Bowers v. Hardwick, and someone check me on the date, I want to say 86, Bowers v. Hardwick. So in that case, at issue was anti-sodomy laws that were really directed at prosecuting gay men. They weren't, because sodomy could be anybody, straight or gay, but it was only used to prosecute gay men. The Supreme Court upheld the constitutionality of those laws. Anybody find it?
86.
86. Flash forward just to 2003, Lawrence v. Texas, 2003, and the Supreme Court completely invalidates those types of laws. So in that period from 86 to 2003, something must have changed. And it wasn't the personnel of the court. It didn't change that radically, but something must have changed. So what changed?
The public opinion.
Public opinion and public sentiment. Then you go from Lawrence v. Texas in 2003, 10 years later, to this case involving Prop 8 and DOMA, and the court strikes those down as unconstitutional as well, those bans on gay marriage. What changed? It wasn't the personnel of the court. The personnel didn't change that much. But it was the sentiment, the public mood, because they knew if they had decided otherwise, they would have been very unpopular decisions. And these cases, from a political, I don't know if I gave you my politics speech. Did I give you my politics speech the other day? One thing that we all have to do in a law class like this is have to sort of check your political affiliations at the door, political biases and political labels. Labels that work in the political realm, like if this were a poli-sci class, don't work in a law class, because conservative and liberal mean very different things when you're talking about how courts work and how judges decide cases. The other thing about it, now this is more on a personal thing. As far as oh, Professor Smith, I think he's a liberal, or I think he's a conservative, or he's a what? I'm not anything. I'm a Virgo. Today's my birthday. I forgot. I got an email from my parents. While you guys were watching that, I got an email from my parents saying, "Oh shit, it's my birthday." You won't celebrate it after you turn 40. It's too painful. So as far as that, I'm not. I'm unaffiliated. I take every issue on a case-by-case basis. I take every politician on a case-by-case basis. Actually, I make a blanket judgment of all of them. They're all crooks. But, you basically have the crooks and liars party and the liars and crooks party. So, take your pick. So, it doesn't matter. And so I don't care about what your politics are or who you voted for in the last election or whatever. And I'm sure that I will manage to offend everybody in this room by the end of the semester. Right? Because I am bipartisan in my contempt for politicians. So the court wants to try to seem as apolitical as possible, but we do know, and we know this empirically, what's fascinating is that there has been a lot of empirical research, like hard numbers research done in the last 10 years to show to really affirm just how responsive the court actually is to public sentiment. And they tend to always, and this is good, I suppose, like the empirical evidence is that the court never really strays that far in either direction. That they tend to, try to be very mainstream and down the middle in how they decide cases. And it's a good thing. And it's good that we actually have empirical evidence to prove that rather than just our instincts about it, right? What's a case, can you think of a case where the court, but there are times, as we'll see next week when we get into some history of the court, when the court does stray too far from the mainstream and gets punished. As in, public opinion of it plummets, people are very angry at the court. It takes a long time for the court to build up that trust again. Can anybody think of any case that they can think of where the court created a lot of controversy and a lot of contempt in the public?
Well, the video mentioned the Dred Scott case.
The most famous self-inflicted wound, the great self-inflicted wound, the Dred Scott case of 1857. We'll talk more about that next week too. Do you remember what that's about?
Basically, a slave decided, I don't remember the details, he went to like a free state and tried to declare himself a citizen. And the court said he couldn't do that essentially.
Right. So it was a slave in a slave state who went to a free state and said, since I'm in a free state, that means I'm free. And the case went all the way to the Supreme Court, and the Supreme Court said, no, it doesn't work that way. You are property.
It's like you're a property of someone.
Right. Right. They're treated as property. We can get more in depth on that next week when we talk about this progression of cases. So there's a case where it was, you're talking about, because remember, you have half the states are slave states and half are not, well, not even half. A minority of states are slave states and a lot of states aren't. And public sentiment had already swung, again, long before it had swung, the majority opinion was against slavery. So you have a Supreme Court decision like that that really diminished the court, people's trust in the court for a long time. It took them a long time to repair that damage. Can you think of a more contemporary, what's the most famous controversial case ever?
Is it
Roe v. Wade. So here you have Roe v. Wade, which upheld the constitutionality of abortion. It's interesting about Roe, I might as well take a tangent here since we won't talk a lot about this anyway. Roe is not an abortion case. Roe isn't about abortion. Roe is a privacy case. It's about privacy. And it comes at the end of a string of cases, starting with Griswold v. Connecticut in 1966, and then Rosenblatt v. Baer and Eisenstadt v. Baer in, 72, and then Roe in 73. And those earlier cases were about contraception. It was about states actually had rules that said you can't buy rubbers. Married people, right? Griswold v. Can you believe this? This is 1966. This is in my lifetime that you have states passing laws that actually reach that far into people's personal lives. You can't get information about contraception. Married people. So that was Griswold, struck down as unconstitutional. Eisenstadt v. Baer, same set of facts but rescinded. Court struck that down as unconstitutional, and then Roe. And all of these are privacy cases. This string of cases culminating in Roe is the line of cases that gives us a constitutional right to privacy. As you'll see later, the Constitution, the word privacy is nowhere in the Constitution. Right? And so what you think of as your right to privacy, most of your privacy is granted to you by Congress and by state legislatures. That's not constitutional law, is it? What kind of law is that, anybody? What kind of law do legislatures pass? Statutory. We'll get to that on Monday. Statutory law. And so most of your rights to privacy are protected by statutory law, but in this case, this line of cases and cases that follow, the Supreme Court created a right to privacy under the 14th Amendment. We'll talk about that. We'll do 14th Amendment next Wednesday or Friday. So Roe becomes a case which to this day has many, many, many people still angry all these many years later at the Supreme Court because of that case. Right? So it is all about that trust, and public sentiment, public feeling toward the court is very important for it to have its authority. What else about the court? Any questions about how it works? How the process works? What, ladies? Who is the woman in the video with glasses? This is your heritage. Ruth Bader Ginsburg, the second woman to be on the court. Before she was on the court, she was a litigator and argued many cases before the Supreme Court, many having to do with women's rights, and won. So she's a very important figure in terms of women's equality. And then who was the woman without glasses?
Sandra Day O'Connor.
Sandra Day O'Connor, the first woman ever to serve on the court. She was nominated by Reagan in 81, I think. Somebody could back me up on that. I think 81. First female on the court. And who's the African American in the video? Clarence Thomas. Was he the first black on the court? Second. Who's the first? First African American on the court. He briefly appeared in the video toward the beginning. He was coming out the door. It said 1970. Civil rights era, very famous litigator during the civil rights era who rose to be on the Supreme Court. We should make like a Trivial Pursuits game with all these types of issues. Thurgood Marshall, really important figure in that. And then the guy with the glasses who was Chief Justice in this video was Rehnquist, appointed by Nixon in 71, became Chief Justice in 85, and then died of cancer. And now the new Chief Justice is Roberts. John Roberts came onto the court in, check me on that. John Roberts came to the court, became Chief Justice in 2009? No, 2006, because it would have been under Bush. Who are the two other, now there are two more women on the court. Who are the two new women on the court? Elena Kagan and Sonia Sotomayor. Right. So now we have Sandra Day O'Connor retires, and now we have three women representing ladies on the court. And Sotomayor, the first Latin person of Latin heritage on the court today. What about, what were they talking about when they were talking about, well, let me ask you this. How does someone get on the court? How do you become a Supreme Court justice?
The president nominates them, and then I think Congress has to confirm.
Be more specific.
The
The Senate, right? And why is that? What do you think?
Why the Senate over that?
Yeah, why is it a two-step process? The president only nominates, but then the Senate actually puts somebody on the court.
So that best reflects public opinion, I guess.
That's part of it, because we think of the members of Congress being more responsive to the public, right? Because the president can become, if the president is very isolated and powerful, then he can become what? A king, tyrant. And so by involving the Senate, that's another example of, exactly, it's a way of trying to prevent an imperial presidency, right? We don't want the president to have too much power, so we involve the Senate. They almost always confirm, but there have been some really famous cases in which the Senate has voted down. Can anyone remember one? So there was I thought maybe it might have rung the bell because he just died several months ago and it was all in the news. Bork, Robert Bork, and he was nominated and turned down by the Senate, and it even gave rise to the phrase "getting borked." Right? You're talking about getting borked. So, but that's a really famous example, and that also was very, very highly political and politicized, that process. But the fact of the matter is, he had made disparaging remarks about blacks and women, and so here we have a president who is firmly behind this guy who has misogynist and racist views, but the Senate, because of its advise and consent role, acting more responsive to the mood of the country or the mores of the country, and it simply wouldn't have been acceptable to too many people at that point. And so we see again how the process actually is responsive to us, meet the people. How am I doing on time? I'm out. This class goes by too fast. Okay, you guys, on the chapter 1 excerpt, this is for next week, for Monday, probably Monday, Wednesday, maybe even Monday, Wednesday, Friday, because these classes are so short. The chapter 1 excerpt, the second blog post that's called How Law is Made. And there's a set of PowerPoints called Sources of Laws. And that's what we'll be working on next week. Thanks. Have a good weekend.
What up? No, I got my show.